Hey, folks, let's return to the Georgia versus Faust cluster fork trial. Now, let's talk about when the state's DNA expert showed up and started to talk about the test she didn't do, sent away, it got returned, yada, yada, yada. Because, folks, something interesting happened. And I wish it was in a good way. Now, folks, sadly, at this moment, Lawn and Krim have day 3. It's taken down. Don't know why. Still. So, I'm going to borrow Katnot Williams because she has the entire day. So we will have to listen to her, and nobody minds listening to Katnot Williams. I'm going to play this quite fast because
this as it relates to, I'm going to jump around a little bit. The DNA.
That's too fast. That's too fast.
Typing of Miss Baker's fingernails.
Exhibit 101, State's Exhibit 102,
All right.
State's Exhibit 103.
Yeah, we are going right into cross-examination here because the prosecution is standard stuff. Oh, you agree with us? How nice.
State's Exhibit 106, and I am going to hand these to you. Okay.
Thank you.
Now I want to discuss specifically with you item 2, which is the Tara Baker sexual assault case. Is that correct?
Yes.
Okay, and is the proper way to address it is item 2? Am I saying that correctly?
Yes.
Okay. Anytime you received item 2, was there a particular method that you had to undertake as far as notating when you had it or notating when you gave it to someone else?
Well, anytime I conduct analysis on it, I would have notes of anything.
Yeah, they are going through what is called as evidence. Who handled it and when?
I've done in my case notes, and then if I've reached the box or the container that the item was in, again, I would seal it, or I'd have to break a seal and then reseal it when I was done with my initials and date on it. Additionally, the barcodes that I identified earlier on the screen, we scan those barcodes when we transfer evidence from either to ourselves or a storage area or to another person.
Sure. So would it be fair to call that scanning is for chain of custody purposes?
Yes.
Okay. And is this something?
Thank you, defense. Chain of custody. Chain of custody should be one of the most important things in any trial, because if there's a breach in the chain of custody, there's no actual evidence. Evidence has not been tampered with. Now that standard has been loosened up severely in some places, which is absolutely horrifying. If the chain of custody doesn't matter, anybody can do stuff with evidence. We saw it in the Karen Reed trial. We've seen it in other trials. An ethical judge would put a stop to that. But here we are.
This isn't something you're typing in. This is something that's computer generated.
I believe this scanning, this was a little while ago, but I do recall that there being a scanning or could have been a mechanism if a scanner was broken or not working, that we may have had to do a manual transfer by signing actual paper documentation, but I don't recall specifically. But that would probably be a backup plan if the scanner didn't work or failed in some way.
Yes, ma'am. 1 second. Item.
Sorry.
I have that information in my notes here.
Excellent. And can you read the items that are items 2J and item 2I, please?
Item 2I and item 2J are supposed to be swabs, different swabs from a certain area of the body. Supposed to, according to the chain of custody, which she was responsible for 24 years ago, which she followed. Supposed to be.
All right, for anyone that's joining in on this case later,
Let's listen to Catnote Williams.
I think it's probably helpful to contextualize. I would highly recommend rewatching opening statements. You can breeze through the prosecutors because he speaks pretty slow, so you can watch it on 2 times without it seeming too fast. And you could probably watch the defense attorney on 1.5. Of course, if you're used to listening to things fast, you can like 2.5 times through it. But one of the things that the defense attorney, that's Ahmad Cruz, who's doing the cross-examination right now, mentioned during his openings was the boyfriend maybe falling out at the time, Chris Melton. His DNA is going to be present too. He's in these DNA results. And initially, he ended up telling police he hadn't seen her in over 10 days. It had been 10 days since he'd seen her. Fast forward to 2024.
Yeah, I've been through that on previous videos. The lying boyfriend who claimed he hadn't been near her for 10 days. And whoopsie daisy, his liquid DNA is found inside her. Yeah, he lied.
Maybe it was 2023. But when the GBI Cold Case Unit is starting to poke around with this case again, giving it renewed attention after this Coleman Baker Act funding came in to help solve cold cases and the attention of a podcast. I forget her name. I'm sure we're going to have her testify. One of the GBI agents talks to Chris Melton again. And she's like, DNA can last and be present for several days. And we sent these swabs out to a lab in California. I think it had to be 2024 because I think that's when they sent the swabs out, November 2024. They send the swabs out to this lab in California. And your DNA and this other individual where we have a CODIS hit, Faust, we need to try to separate you. So is there any explanation why your DNA might be showing up? It can last a few days, like 3 to 5 days, 2 to 4 days. And he changes his story then and says, oh, I saw her that last Sunday, which would put it about a 6-day window. So that's years later, again, changing the story when being confronted by somebody who's specifically telling Chris Melton, we need to be able to explain why your DNA is also present. Because
yeah. Now, a proper investigator would have looked at that and said, holy crap, we have 2 suspects. But this lead detective decided, no, I want to charge the black guy. So I'm going to tell the boyfriend whose images of his hands, severely injured hands, as if he had been as if he had brutally beaten somebody up. Boyfriend brutally beaten somebody up. Liquid DNA in the victim. You would imagine that he would be a suspect, but no. The lead detective was focused on the black guy. So she went to him, the boyfriend, and told him, you have to explain this so I can exclude you. Not confrontational, an ethical investigator would have confronted in an interview with the sheer fact that he lied. You lied. Why did you lie? I didn't lie. I didn't lie. I don't know how the boyfriend acted. And see what information. But no, this lead investigator decided to, no, I'm going to help this guy invent a fucking story. Reasonable doubt against Mr. Faust.
his initial story was he hadn't even seen her in 10 days. So very important context, guys. I do recommend going back and watching opening statements if you're coming late into this trial.
So I do not have those items listed in that manner in my notes. So I don't know what correlates to I and J or anything like that.
Hey, Allie.
Sure. Would the chain of custody report refresh your recollection?
It may. Okay.
Scroll to check it, make sure it's accurate, and try to change anything.
Okay.
Yeah, and to the witness yesterday in the previous video, if somebody asks you, will looking or listening refresh your recollection when you claimed, oh, I can't remember, the correct answer would be yes. Not as the witness did in the previous video. I don't know.
Excuse me, refresh your recollection in regards to item 2I and 2J.
Yes, I have oral. These are referencing oral swabbings. I have them as being part of the
Oral swabbings. This is the original medical examiner, DNA expert. She has them listed as oral swabs.
sexual assault kit as well. I just don't have them indicated as I and J in my notes.
Sure. And you can use the document that I gave you or your notes if you like. Can you tell the jury the dates that you first received item 2I and item 2J?
2I and 2J. Again, if you missed the beginning of this case with the openings, these are supposed to be two different swabs. They were labeled as being oral swabs. They're sent out to some lab. The lab contacts them back like, hey, we think you made a mistake. These are actually vaginal swabs.
Yeah, Cat got there before this witness got there. Folks, since there is no chain of custody after she left, so 20 odd years later, swabs have magically been swapped into other evidence bags. And there's no chain of custody. None. And all of a sudden, swabs magically ends up in different evidence bags where they shouldn't have been. So as of now, in my personal opinion, the result that says Mr. Faust did the vaginal intercourse, we actually don't know. It might be that it was just a BJ 3 to 5 days before. And there's no way of knowing because the current investigation fucked this up so badly that even though in my personal view, the case is stronger against the victim's boyfriend, I don't think you can convict anybody anymore or should be able to convict anybody anymore. That's not justice. That is not justice, folks.
And the state in opening told us they'd be able to explain this away. So now he's getting into this item number 2I and 2J.
Okay.
Items. So my notes indicate that I performed analysis on those items on January 22nd, 2001. As far as the notes that I have with me today, I do not have exactly when I received it first. This document states that it was on your laptop, identifies it as being resubmitted on February 15, 2024.
How about the first time you obtained it? And I'll let you know this. I'm not trying to put you in the hot seat. You're not in the hot seat. Which date from either record did you first receive it?
Going
Oh, my
to,
apologies, I didn't see this down here.
No, you're fine.
going to slow it down a bit.
And you can scroll to 2I and 2J if you need to.
All right, so for item 2I, it appears that my first possession was January, oh, I'm sorry. Sorry,
No, you're fine.
January 22nd, 2001.
In 2I, is it fair to state that 2I is a oral swabbing?
That is what it was labeled inside of the kit on the container.
Okay. And is 2I A or B?
2I. So I do not have it in my notes as that. I have oral swabs A and B, but because I don't have that I in the J, I'm not sure which correlates to which on this chain of custody.
That's fair. You answered my next question, but you have it as oral swabs A and B.
Yes.
Okay. So to your knowledge, you tested oral swabbings. Is that right?
Yes, I had two separate containers. I don't recall if it was a box or not, two containers that were labeled oral swabs.
Okay. And would you happen to recognize these
I should recognize them with my initials and case numbers on them.
on this here?
I should be able to see my case number and initials on there. Yes, I recognize these as the envelopes that I tested with my date and initials, marking the date that I tested them, opened them for testing.
Okay. Your initials are on those packages?
Yes.
All right, and I went and looked. The two names of interest from the GBI cold case unit, so closer, like recent times, like this 2023, 2024, 2025 time period. It's Elizabeth Bigham and it's Jeremy Howell. Those are the two names that have come up as from being from the GBI cold case unit.
Just so you wonder, yes, I have asked Kat if I could use her stream for my video, since Lon and Krim have pulled theirs from their channel. And I know there are others out there, but I'm not entirely sure about those. Let's just say, out of precaution, I chose Cats.
Bigham is the one that was speaking with Chris Melton. And hey, we're trying to separate why we're getting DNA matches to you and this other guy that we got a CODIS hit for. So can you tell us anything? Are you sure you hadn't seen her in 10 days?
Yeah.
So as of January 22nd, 2001, you had oral swabbings. Is that fair to say?
Yes.
Okay. After January 22nd, 2001, did you see those swabbings again?
No, I don't believe I did. I mean, it is possible that they were, let me, one moment, please.
Take your time.
I have a lot of notes.
I like this witness. She's very, very thorough and apparently
So
very, very proud of her work.
I imagine I saw them again, but did not conduct further testing on them because when I did further testing on the toenails that were in this kit, they would have been in there, but I did not make record of that because I went in just for the toenails.
And what date was that?
I conducted the testing on the toenails on March 5th, 2001.
Okay, so you still would have, because it was in one whole package, you'd have had those swabs.
Yes.
Okay, excellent. This is a really important question, and this is my last question for you, and I'd like you to let the jury know. Can you tell us what presumptive testing is?
Presumptive testing.
Yes, ma'am. Can you let the jury know what a presumptive test is?
Presumptive testing, I believe, as I mentioned earlier, is a test that presumptively sorry, that's the wrong term. It's a first test that we use to kind of determine if any additional testing is needed. So if a presumptive test is positive, further testing is needed to confirm that particular body fluid. If it is negative, then at least at that time, we stopped analysis.
My follow-up question to that. So if After a presumptive test, or let's say this, what does it mean when a presumptive test comes back positive? Can you let the jury know what that would mean?
Yeah, when a presumptive test is positive, it means that it indicates the presence of that particular body fluid, but it does not confirm it. So again, additional testing would be needed to say for certain that that body fluid is indeed blood or semen or whatever you're testing for.
Okay, and if you don't confirm the presumptive test, what does that tell us?
It basically means there's an indication of that body fluid, and generally that sample would go forward for DNA testing to determine who the sample came from.
Would it be fair to say
If you don't,
that
if you don't do it, you can't say it's confirmed.
Don't let me not get it wrong. What's the type of testing needed after presumptive testing? Is it just confirmatory testing?
Yeah, we refer to it as confirmatory testing.
Okay. If confirmatory testing is not done, is it fair to say that we don't know whether or not that substance is present, whatever it may be?
I wouldn't go that far necessarily, because when you conduct DNA testing, especially at that time, and considering the technology that was available, we retrieved a DNA profile from something. And what was tested for was blood. So to me, at that time, with the technology available, I would be very comfortable to say that the DNA profile came from blood.
Oh, I hope he asked, do you think today's technology is better or worse?
And please forgive me. Please forgive me. So I'm not speaking of DNA testing.
Sure.
I'm not speaking of DNA testing at all. And please forgive me for not making that clear. I'm just speaking on, or I would like for you to explain to the jury, and not in regards to DNA testing, just the principles of presumptive testing versus confirmatory testing, and what it means if you have a presumptive positive versus a confirmatory positive, or if you don't confirm at all. That's what I'm trying to get at. Does that make sense?
Yes, sir.
Okay, thank you.
So when you perform only a presumptive test, and that
By the way, this is what the prosecution should have done. They didn't.
is the standalone test, and no further testing is done, you cannot say that 100% this is that body fluid. If you do add the confirmatory test and do both in conjunction, and they're both positive, then you can confirm the presence of that body fluid. Additionally, though, in combination with DNA testing and a presumptive test for body fluid, that can also be confirmatory, as well as the DNA has to come from something.
So outside of DNA testing, if we have a test that's deemed a presumptive test, we would need to do confirmatory testing to ensure that it's properly identified.
That's correct.
All right. Thank you so much for your service to this great country. I really appreciate your time.
Thank you.
Any reject, Mr. Bolden? Go ahead.
Yeah, just listen to the...
Follow up a little bit on some of the last questions. Did I hear correctly that presumptive testing, along with other environmental factors surrounding the test itself, may be helpful? Is that what I heard you say? Or something to that effect? I'm not trying to put, let me back this up. Is presumptive testing, in your opinion, helpful?
I do believe presumptive testing is helpful because there's a lot of, when you open an item of evidence, let's just say that you're looking for blood to see if blood is present. There can be all kind of staining on an item. If, for example, let's just say have a pair of khaki pants. You open up the pants, and again, you talk about visual analysis. So that's the first thing I would do when I open it up. And any stains will catch my eye. If you see stains that are reddish brown, those catch your eye, so you circle them and you do this presumptive testing. Well, many things can look like blood. Sometimes chocolate looks like blood. Sometimes, Georgia red clay looks like blood. There are many things that can look like.
Sometimes rust looks like blood. Still thinking of you, Zachariah. Yeah, the Zachariah Anderson case. That was a cluster F in a division of its own.
Blood, but doing that presumptive testing can initially go, okay, we can put that one aside because it's negative. I don't need to do anything further with that. Let me focus on any other stains that I see. And those stains that are presumptive, then you have to make a decision based on the case and the situation if you're going to go further to confirm it, or if it goes to DNA analysis or it stops.
Any request, Mr. Cruz?
Have you heard of Lugol's iodine test?
I have heard of it, but I have never used it.
Okay. Do you know what it is?
I am not confident to speak to that at this moment. I have never used that test, but I know I have read about it.
I like this witness. She takes, not only does she take pride in her work, she won't tell something she's not sure of. She will not testify to things she's not sure of. Please, please, any DNA expert out there, medical examiner, reconstructionist with blue paint, this is how you're supposed to testify. If you don't know or are unsure, don't guess. Just say, I'm not comfortable testifying about the things you just asked me about. It really is not harder than that.
Ask you this. Do you know if it was in existence in 2001?
I do not know if it was in it. I do not know, because as part of my reading and training, we read about historical things, and I apologize, I've never been trained on that, nor have I ever used that technique, but I have heard of it. I just don't recall.
Absolutely. That is fair. The computer that I gave you,
Yes.
do you recognize that document? The chain of custody report?
I do recognize it as a chain of custody that was generated at the GBI, but I have not seen this in probably 20-something years. It's not a part of my notes today that I have.
Sure. Can you take a moment and just refresh yourself with that document?
So,
And just in regards to your, and just to save time, just in regards to your portion of that report, chain of custody report, in regards to items 2I and 2J, and the, I think the first page.
Yes.
Okay. You do recognize that in regards to those specific items in the first page?
This first page, that's what you're.
Correct.
Yes.
Okay. Is it fair to say that that chain of custody report, at least with your notations on it, would have been made at or near the time that you received or relinquished possession of those items?
Yes, that's correct.
Would it be fair to say that the chain of custody report in regards to yourself was made by you and you had personal knowledge of whether or not you had those items or relinquished those items at that time?
This is defense in preparation of what might come later, because we're not really sure the lead investigator will be called by the state. They will try to get somebody else to talk about and verify what the lead investigator did and didn't do. Why? Because the state has a shit case, and I don't know if it is as bad as with Michael Proctor, but it's bad enough what the lead detective did and didn't do.
Yes, I should have knowledge of whether I have an item in my possession or it's somewhere else.
And is that chain of custody report kept in the course of regular conducted business of the GBI?
Yes.
the business record.
And was it the regular practice of the GBI when officers received items or relinquished items to make a notation on the chain of custody report?
Yes, it should be noted on the chain of custody. And at any time the evidence was received or transferred from a location to a location or a person to a location.
Okay. And is that a fair and accurate report? Does that appear to be altered in any way?
Again, I have not seen it in a really long time, but it appears to be what I recall as a complete chain of custody. There are items on here that I never had possession of, so I can't speak to that.
But to your items, does that appear to be altered in any way that you had possession or relinquished possession at the times notated on that report?
To the best of my recollection, it appears to be consistent.
Your Honor, I am going to mark this USB as Defense Exhibit 21. It will contain a redacted version of the chain of custody report, only including items 2I and 2J, and Ms. Corsi's possession and relinquishing of items 2I and 2J. Does that make sense, Your Honor?
Would you rephrase that?
Sure. So I'm moving to introduce Defense Exhibit D21.
Got that?
Yes, ma'am. And what it would consist of is a redacted copy of the, and I can make it easier for you. It'll include Ms. Corsi's portion
Don't deny
of possessing items 2I and 2J,
Can't deny
which
it.
Ms. Corsi has identified as oral swabs A and oral swabs B, as well as the first page identifying items 2I and 2J as oral swabs A and oral swab B.
All right, thank you. Mr. Bolden, any objection to the request for admission?
Your Honor, we don't actually have the document yet. So like, I'm not exactly sure exactly what Mr.
You moron. Folks. This is stuff the state handed over to the defense. When he says, I don't know what the document is, he's lying. And I don't care. Because the state is the state, is the state, is the state. If somebody handed this to the defense, meaning the state had possession of it, it doesn't really fucking matter. It's yours, Mr. Prosecutor. It's yours. Out of courtesy, he can show it to you. And your expert already testified to that, yes, this is my chain of custody. Let's see what the judge says.
Cruz is intending to.
I'm sorry, you didn't obtain chain of custody reports? Is that what we're saying here? Or is he just nitpicking and saying he doesn't have the specific thing to see what would be redacted? So he's just going to object on some specific for the sake of it.
Yeah.
So if you need some time to produce it, because I just don't understand exactly what it is. I think I do, but I have.
It is a fucking chain of custody document that your expert, who you brought to this trial, has testified, yes, this is it. Asshole.
I haven't seen it. So at this time, I would object.
By the way, Kat does not curse on her stream. Do not apply my foul language negatively on Kat Not Williams. It's just me using Kat Not Williams' stream because Lon and Krim have taken day 3 down for some reason.
Once that document is produced, I'm happy to take a look.
Sure. May I produce it to the state, Your Honor?
Yes, and I will hold off ruling on that particular.
May I produce it to the state? That's shade. Shade.
Oh my
Request
gosh.
until
Holding
that
teeth.
process is done. You may continue your cross-examination.
Yes, ma'am. May I ask this? Can it be?
Yeah, folks, this will go out as a premiere. And after the premiere is done, I'm going to send you over to Kat Not Williams' stream regarding this trial. But as you can see, the defense is slowly weaving the thread of reasonable doubt here regarding the chain of custody, regarding these items, which when this witness back in 2001, when she sealed it, signed it, those were oral swabs. 2024. These supposedly, since 2001, sealed oral swabs were sent to this specialized lab and came back as vaginal swabs. It's not a coincidence, folks. And here's the thing. If an investigator is prepared to alter evidence we can trust the evidence. All right, folks, that is what I had for you. Everybody say hi to Kat, say it's a Viking raid, and I will see you all in the next stream or video. Bye-bye.